if you have questions, give us a call. So we're going to go ahead and get started. Spencer, tell us what happened recently with the passing of recreational marijuana.
So as you're all aware that we recently passed recreational marijuana. One of the items is obviously it's going to have some effects on employers. One of the issues obviously is no law exists in a vacuum. So we've got we're going to talk about how this law kind of is impacted by some other laws, including the Drug Testing Employees Act and Arizona medical marijuana as well. So just in summary of the law, it was recently passed.
There it is.
There it is. All right, so it was Proposition 207, as you're familiar, passed with about 60% of the vote, and it was certified, and basically it legalizes recreational use and possession. It's just a summary. Supposedly it's supposed to help generate some tax revenue and things like that, which will be helpful. But for employers, really what it does and what it doesn't do is kind of the important thing. So yes, it may be a surprise that marijuana use was somewhat prevalent in the community before. It's going to get more prevalent, but sorry, next slide.
Yeah, no, I think it's important. I was just going to say it's important. This will preface our next slide, which is it does allow for individuals to actually have and grow marijuana. So this is going to be one of those things that can be the impact that we're going to talk about.
True. All right, but kind of more importantly for today's purposes, what doesn't it do? So it doesn't restrict you as an employer to maintain a drug and alcohol-free workplace or affect the ability for employees to use it or use it or be under the influence of it at your workplace. So so pretty much if they're using when they're not at work, it's not as obviously as hopefully it doesn't affect us as much. But the law doesn't make it so that every workplace is now that you can possess or do drugs there. It just means that it's no longer a criminal behavior. So it's similar to alcohol now. Just like you can require that employees not bring alcohol or consume alcohol while working for you. It's just similar in that way now.
That's pretty impressive. That's actually a critical point, because I know a lot of employers were worried about, oh man, what does this actually do? Now that it's recreational, can they bring it to the workplace or other things like that? And to be very clear, obviously here the slide shows you, but the answer is no. They cannot bring it to work. They cannot use it at work. So those are pretty critical things. There are some byproducts though that we need to talk about as to how it does impact the workplace.
So potential impacts of the new law, like we talked about. So as we said, marijuana use wasn't particularly not prevalent in the community before. Obviously, for your employment, based on who you're recruiting, how you're trying to get your employees, a larger percentage of individuals may be using now more than were before. The other impacts is if we want to make sure that we have written drug policies and enforcement options for us. And the major reason we want to have that is if we're trying to do an ad hoc system where we're drug testing people without a formal drug testing policy, we can run into trouble. And also in drafting in our policies and executing them, we want to make sure we're doing it in a way that isn't discriminatory in regards to certain groups, because that has high potential to lead to lawsuits. And also to remember, medical marijuana card holders still have expanded rights, in the workplace. We'll visit briefly about that, in a moment here as well.
So higher usage is not a question of if, it will be higher usage among people. We've talked to actually many employers that say, and you may be in the same boat, hey, if I screen for marijuana or for other substance, I might not have a workforce, right? So there's questions that we walk through with employers all the time as to how to best set up a drug testing policy and enforce it. Spencer's going to go through why this is critical. In Arizona, the drug testing policies, if you don't have one, you can actually, and you try to drug test, then you can actually be sued for doing so. There can be claims that arise from that. And and to be very clear too, Spencer, you said, and this is right, the medical marijuana usage is still applicable. This does not erase that. It does not erase any of the expanded rights for those that are using for medical marijuana. So it's important to keep that distinction very clear when you're looking at somebody that maybe comes to you and either shows signs of having used or you test them and then they do have marijuana in their system, do they have a card? And then you have to go through other steps that Spencer will talk about.
Indeed. All right, so moving briefly to the Drug Testing of Employees Act. So this was passed by the legislature after the medical marijuana was passed to try and help employers keep a drug-free workplace effectively. So the Arizona Drug Testing of Employees Act does a couple of things. It establishes the drug and alcohol testing policy requirements. It defines the meaning of impairment in safety-sensitive positions. It establishes disciplinary procedures, and most importantly, it provides employers with protection from litigation if they're following the policies that are permissible under the law. So to have a compliant policy, there's 10 simple steps, and I'm going to tell you that we'll review these, but mostly we need to review your actual policy. If you want a policy in place to make sure that we're compliant. But just in a summary, you have to have what your policy is. You have to describe.
Well, let me just say this too, Spencer, and this is it's not just a verbal policy, right?
Correct.
It has to be a written policy that is given to or provided to the employee. Usually we do this at the time of new hire when people are brought on. It's either in your employee handbook, or some people have a separate drug testing policy that's part of their new hire paperwork. So it does have to be written though.
And on your onboarding, if you're doing pre-screening drug tests prior to employment, you want to give it to them prior to that drug screen. So basically, if you want to make sure if you are testing and you want to make sure you're protected, it has to be compliant with this law. Like I say, one of the easiest ways is to send it to us, and we can take a look and make sure it's compliant. Because effectively, if you're doing it in a way that doesn't comply with this law, you do not get the protection from liability. And
when we say liability, I think it's important to understand what that means. So liability is wrongful termination, or one of the issues that's popped up in some litigation recently is not all the tests, especially for marijuana, can you conclude that there's some sort of impairment. You can only show maybe use in the recent or distant past even. It's not as simple as alcohol. So the testing for marijuana is coming up, I'd say. I've seen some things that they're trying to be better at how they test, but one of the issues is it's not the same as an alcohol test.
Yeah, so the issue is use versus impairment. For alcohol, pretty much we have established kind of guidelines. What's the legal limit? What's the and we have a test that instantly yields the results of if you're above that or not above that, right? For marijuana, there is no such test. We can just test pretty much has it been in your system, and effectively if it can remain for more than a month, that's not really a great sign that you're under the influence of it at any particular time, just that you have used it.
Yeah, no, that's exactly. So a written policy is critical. These are the 10 steps in the law. This is actually directly from that statute. So these are things that you need to have in the policy if you're trying to make it so that you are, you're prevented from, or people are prevented from suing you for having a drug testing policy and actually enforcing it. Go ahead.
Well, and it also talks about kind of the disciplinary procedure. So what your options are if someone tests positive. Basically, you can have them enroll in a diversion program or a rehabilitation program. You can suspend them, you can terminate them, or if they're
And I'm going to pause 1 second while we figure out if everybody can hear us.
Sorry, probably an important first step.
All right. Let me do my sound check and see if that works a little bit better. Okay. I've gotten the yes, we can hear you now. So that last part was just talking. I had the microphone at half noise and now it's at full noise. So hopefully everybody can hear. But the last part was just about the disciplinary procedures. I was focused on whether the sound was working or not, but let me see, Spencer, did you talk about how if you don't have a drug testing policy or if you don't have a method of administering the drug test, how you could fall into discriminatory practices?
Yeah, so if you don't have a policy that you're enforcing evenly, the issue then becomes who you're testing and why you're testing. Even if you have a drug policy and you're administering in a certain way, you could have issues.
For instance,
say if you're a hospital or you're or you're a hotel and you're drug testing all your housekeepers, but only your housekeepers. If your housekeepers are tend to be more of a minority population, that you're open to a potential lawsuit where you're having a disparate impact based on their race.
So it's a discriminatory practice based upon Title VII,
Right.
them being a part of either a race, a protected status of race, gender, national origin, religion, or disability. Okay.
Yeah, so anything that's protected under Title VII.
Okay. And you know what's interesting is we have seen these types of lawsuits, not directly obviously with marijuana yet, but there has been these types of lawsuits where if there's a certain testing requirement, let's say to enter into a job, and it requires the person to be able to have completed a high school education or something, whereas the job doesn't really require those things, that could be found to be a disparate impact towards people in a minority status. So
Yeah.
this is going to be one of those that I think honestly has the most potential for legal action here. If outside of the fact, if you don't have a drug testing policy and you try to drug test somebody, that will be a direct issue. But I think this will be the secondary issue, which is are people, employers drug testing evenly amongst different groups of people?
Yeah.
So, all right.
And as the major reason that we need a drug testing policy that is compliant is because then if we're doing it and administering it, in the way that they want it to be, then you're protected from actions by that employee that you've tested, or potential employee that you've tested and stated you're not going to employ based on the results. So if we do that, basically you have the ability to you can cut off potential liability from employees for saying you didn't have a policy or you didn't administer it the way you were supposed to.
So I do like the part where it says it gives you this kind of a baseline of if you have a drug testing policy and you follow it, your actions are deemed to have been in good faith if you move forward with some sort of disciplinary action.
Mm-hmm.
Now let's take the reverse of that. If you don't have a drug testing policy, you are not given this good faith kind of baseline as to what your actions are. So not only do you open yourselves up to discrimination or I should say litigation under the actual Drug Testing Policy Act, whether you were able to drug test somebody or not. Secondly, you open yourselves up to issues of, well, what was the reasoning for your drug testing?
Yeah.
Okay.
If you don't have a drug testing policy, to be simple, you should not be drug testing, pretty much under any circumstances. If you feel that person is impaired, you can discipline based on their impairment, even without a positive drug test. But if you as you don't have a policy that you're administering, you do not want to administer a drug test.
And this can come up even in instances where, let's say, somebody gets injured at the job. If you don't have a drug testing policy, that can be a problem if you're sending somebody out to get a drug test.
Indeed, and for example, it brings up another issue with marijuana is, once again, use doesn't necessarily mean impairment. Just because you tested positive after a workplace incident, was there some conduct or anything or something before that we can show led to you having diminished capacity that caused the accident? If that's so, then then there's a possibility for rejection. Just having it in their system, not knowing when when they were in it, doesn't when they used it doesn't offer the same protection.
Perfect. Okay, so how does this correlate then, or interrelate with the Medical Marijuana Act?
So the Medical Marijuana Act introduced kind of two concepts that that was important. One is basically what is what's a safety sensitive position. So a safety sensitive position is basically one that is that either interacts or does something in a way that just by them potentially consuming marijuana, we're concerned that they could be impaired in a way. But basically it makes it so we can either kind of change those job duties, or if it's a completely safety sensitive, you can exclude them from the position. But you can't base that that discrimination is simply on their status as a card holder. So basically, it's the other part is basically for medical marijuana, like we talked about, just a positive drug test, specifically if it's for medical marijuana use, they're entitled to use that under Arizona state law. So if we get a positive drug test and they have a medical marijuana card, which if they disclose, you can verify through the state. You have the opportunity to basically we put a pause on any disciplinary action if they say they have a card, and then while you confirm that, and if they confirm it, then it kind of becomes a drug test plus is what kind of we're calling it. Because if you don't have observed conduct that shows that people have been impaired, then just them testing positive on a drug test isn't enough to show that they've had issues at work because of the drug.
So let me just take one step back. So for recreational, if you have a drug testing policy, you drug test, they have it in their system. If they don't have a medical marijuana card, you can terminate on the spot or take appropriate discipline at that time.
You can. If you have the policy and you've tested according to the policy, and they test back positive, you can take whatever disciplinary act you want under the law.
Now, moving this step forward to the medical marijuana, the recreational marijuana law does not supersede or does not set aside the medical marijuana act. So you still need the drug testing policy for both. Mm-hmm. But on top of that, you're saying there's these two additional things to consider, which is one, the medical marijuana act says just because somebody tests positive for marijuana in their system doesn't mean that you can actually take any disciplinary action unless you've designated their position as safety sensitive or there's an impairment. Is that right?
Correct.
Okay.
So if the position is considered safety sensitive and they've tested positive for marijuana, basically we can, you can still, I'd say, I'd say we have some obligation to enter into kind of an ADA interactive process in regards to kind of their role. Can we change the role so we don't have the safety sensitive obligation stuff to it? But other than that, just them testing positive isn't really a reason to exclude anyone or take any action unless we have some observed impairment where we can show that that objectively they had some conduct that showed that they were impaired by the drug.
So basically what we're encouraging people to do with this onset of the recreational marijuana is one, make sure you have your policy in place on drug testing. And two, this dovetails with the Arizona Medical Marijuana Act, which is if you need to have safety sensitive positions designated, you really need to do that from the beginning of the employment. So you have positions like, for instance, if somebody's a forklift driver or any sort of vehicle operator of any kind, those are safety sensitive positions. And there's a list of them and we can walk through that on an individual basis if you have questions. But that almost gives you an out if there is a test that's performed for drug testing and there's marijuana found in the system for anybody. Otherwise, you're left to figuring out if somebody's impaired, which can be a pretty difficult task. I know we won't have time to jump all through it today, but it's observing impairment and then making sure it's actual impairment from the marijuana use is going to be it's always a problem. It's always a problem. So
correct. So what it means to employers in regards to so under medical marijuana or under recreational marijuana, we can still prohibit the use, possession, ingestion, or working while under the influence of it. We can still discipline employees if they've ingested or working under the influence of it. And if it's a safety sensitive position, we can talk about reassigning or transferring those particular job duties to a different position, if it's available. Obviously, if you employ one forklift driver and the position requires them to drive a forklift and it's safety sensitive, it doesn't mean that we have to create a position for someone. We can just say you can't have this position.
This is what you hear of a zero tolerance policy on the premise, right? You hear these zero tolerance, and what that means is nobody, and if you do have to have this spelled out, but it's no use, possession, ingestion, or working while under the influence. It doesn't mean that, especially for medical marijuana, that somebody can't have used previously and then come on unless they are impaired. It
being in their bloodstream isn't possession, right? Yeah. So it's or impairment necessarily. So
I'm going to jump through this just because I know we've talked about it. So if you don't mind, we'll jump through the impairment. If anybody wants to look at this, the statute citation is there, ARS 23-493. Safety sensitive position, same. these are the ways that you can designate those positions. So the biggest takeaways on this: do you have a drug testing policy? Do you have it or make it available to all your employees? Because having one alone isn't enough. It actually, the law says you have to make it available to all of your employees. Have you designated safety sensitive positions? What are you doing to ensure that you're not drug testing in a discriminatory fashion? So like we talked about, it's not based upon somebody's, either directly or indirectly on somebody's protected status. And do you have predefined penalties if somebody does drug test? Is this a zero tolerance policy? Or do you have other policies that you might want to put in place? Mm-hmm. Anything else on that, Spencer?
Not really. If you have any questions, obviously you feel free to follow up with us. That's what we're here for.
Awesome. A quick PPP update. Well, let me just say this. So the biggest takeaways there then too are recreational marijuana does not change the underlying ways that an employer can enforce discipline against employees.
Correct.
Which is big. It's big.
Effectively, it's just going to make uses more prevalent in the community, but you know, but you still have all the tools in your toolbox, essentially, as long as we've done it the right way.
Yeah, awesome. So the PPP update, there's been quite a bit going on. A lot of you probably follow the news. There's things that are hopefully going to pass soon. There's nothing that's passed yet unless it did this morning and I didn't see it. But let me just start with first, there's the PPP loan forgiveness. We've been actually helping people fill out applications for that. Some people can actually move forward, and I've heard recently that some people have actually received forgiveness of their loan. Other people I know, and this mostly through smaller lenders, I've seen a lot of people not even be able to apply for forgiveness yet. It's interesting how each lender has kind of different parameters and what they're willing to do. But so if you're in the boat that you're looking to, or you already started the application for forgiveness and you need help, let us know. Or if you have a good accountant, those often can be a good resource for you to go and just ask the questions on, hey, how do I fill out this specifically? The phase 2 of PPP is what is allegedly coming. They're trying to target people that have been truly harmed by the coronavirus. Obviously, at the start of the coronavirus, the fear was everybody was going to be harmed. And as it's panned out, we've realized that some businesses have been really impacted and others have been sort of impacted and others have grown. And so this next PPP phase is supposed to focus on those that have been really impacted. They have also set out a few things that are going to be relevant to everybody who has a PPP loan currently. One, simplifying the loan forgiveness process. If you have $150,000 or less of a loan, they're trying to make it simple for you to get loan forgiveness, mostly because the resources they have, they don't want to be using that on people that have received less than $150,000. Now, the second biggest thing is reversing the IRS's ruling on how they're going to allocate, how you're going to be allowed to track expenses. So currently, the IRS has said you cannot, if you receive PPP money and used it towards payroll, you cannot take that payroll as a deduction against income this following year. What in essence that does is it takes away deductible expense, which means it actually makes it so that you show more income, which then means that you have to pay taxes. So it's a reverse, kind of a backdoor way that taxes are going to be required to be paid on this PPP money. A lot of people have been frustrated by that. So there's actually been a big push by a lot of accounting groups across the nations pushing this to say, hey, we need this changed. The last thing is on this new PPP loan, the extension of payment of principal, interest, and associated fees on some SBA loans. So if you recently received an SBA loan, that's something that you're going to want to look at. Let me just check here real quick to see if we have, we have another person who's showing that they just received confirmation that their PPP loan was forgiven. That just happened, it was less than $150,000. So that's awesome, that's great news. Again, I just talked to somebody as recently as yesterday who their lender will not move forward with PPP loan applications at this time. They're hoping to see this new PPP phase 2 make it a lot more simple for them. So very cool, very cool. That's great. So hey, we do want to follow up and say if you have questions, feel free to contact us either via email or phone call. If you have a chat question right now, we're open to answer a couple questions. Let's see. Yeah, it's just about 8:30. So we hope that this has been helpful for you. And if you have questions on either recreational, medical marijuana, drug testing policy, or this PPP phase 2, let us know. And I just got a question about emailing the recording. Yeah, we can email this recording out for sure.
For quality assurance purposes.
That's a good point. Actually, we do need to put the tagline on here that as things continue to change, one of the points that Spencer made about recreational marijuana was there's still regulations that will be passed relating to this. That's supposed to be done by April 1 of 2021.
Correct.
So that means what we know now is just what's in the law, not what's going to be applied by the Arizona Department of Health and Human Services, I think is who's doing the regulations.
Correct. So we should get some more guidance in regards to it. They gave the legislature a couple of months to kind of get their acts together.
Yep. So there's the caveat we always put out as lawyers, right? Unfortunately, is well, we only know what we know now, and so the PPP2 and this recreational marijuana will keep you updated. Let's see, another question.
What banks?
Which banks have done this so far to your knowledge? I've seen Chase. I've seen, like I said, I'd call them the bigger banks is what I've seen. I don't want to call out some of the smaller banks. I don't know if that's a bad protocol. I know even the one that we had here at our firm, it's a smaller bank, has not processed loan forgiveness applications yet.
Some of the small banks are waiting because some indications is that the process is going to be streamlined. So that's why some of them are holding off. They don't necessarily have the resources to file. And I don't mean to bag on small banks or things like that, but it's just why dilute the resources if you have the opportunity that's going to be simpler. Any day now is when supposedly this legislation is going to be passed. So.
Well, and let me ask this: if anybody on this is willing to share, I see a few people have even commented here. So there's one that says Cabbage. Somebody used Cabbage for their loan. That was just forgiven. Anybody else willing to share who they've used? Alliance Bank.
Okay.
Yep, Alliance is open. So I've got a couple people with Alliance. Okay, yep, so that's helpful. That's awesome.
Well, and apparently Alliance is processing forgiveness applications as well, and some have been forgiven. So
perfect.
So that's great.
Let's see. Okay. Excellent. Well, we appreciate you being here today. We're going to do this once monthly, some sort of webinar each month. There's going to be a little legal update, and there will probably be PPP updates each month because it just keeps the ball just keeps rolling on that. So thanks for joining us today. We look forward to talking with you soon.
Have a great day.